everyone. Today we are talking to solicitor Patrick Green and litigator Adam Palmer, who work together at Colman Coyle, an international law firm born in central London. They have a specific focus on England and Wales, and we're talking everything probates with probably a very logical thing that I may be hypocritical in saying because I don't have one, but that you want to get a will sooner rather than later. So Patrick, Adam, why don't you please both introduce yourselves and also explain the difference between a solicitor and a litigator to an American living long time here.
I'm Adam. So I've been at Colman Coyle now coming up to 13 years. So I'm a senior associate in our litigation department and deal with contentious probate inheritance disputes alongside Patrick. In answer to your question, the difference, we are both solicitors, so we're both regulated and qualified as solicitors. Litigation is just my area of practice, so I get involved in the contentious side of matters, whereas Patrick will deal with the non-contentious side of things.
Okay, fair enough. Patrick, what do you want to add of what your work is and your qualifications?
Thanks. Yes, I'm a solicitor in the firm's private client team. I specialise, as Adam said, in non-contentious work, which is often wills and trusts, tax planning, and estate administration. I've specialised in this area for about 20 years now, and been with the firm for about 8 years.
Who should be listening to this podcast? Who would benefit from listening to this podcast?
I think it will be a variety of people, Jennifer. There's obviously people who need to look after their affairs, legally speaking. So they would want to put their wills in place or update them if they've got existing wills. It could be people who are dealing with someone's estate where they've already died, just looking for advice or a steer in the right direction as to what to do. Potentially, it could be a beneficiary or someone, a family member who's perhaps going to inherit shortly or something like that.
So, Patrick, I think it makes sense that you are the first till we reach the more extreme Adam. Let's set this up a bit more. Like, why should you have a will? What is all happening with estate management that can be done prior to your passing?
Why everybody should have a will is really for two reasons. Firstly, it enables you to determine who you want to benefit when you die. And secondly, it gives you the opportunity to name the person or people who will legally be entitled to administer your affairs when you die. There are default provisions, statutory provisions that come in when somebody doesn't have a will, but they're normally regarded as somewhat inflexible. And also they don't bring in certain types of beneficiaries or people you might want to benefit. For example, unmarried partners wouldn't benefit under the statutory rules. Other relatives, more distant relatives, charities don't benefit under the statutory rules. So if you're looking to benefit a charity, you would need to have a will. And also, as I said, you want to name somebody who can actually manage your affairs automatically when you die. That person's the executor named in the will. And when you die, they would automatically have authority to start dealing with your affairs. And that can be particularly useful, for example, if you've got, say, a property rented out and you need to deal with tenants, you need an executor named in the will who can start dealing with matters. So they're the two main reasons. There can be others, for example, maximising tax benefits on death can be done through a will more easily than without having one. And obviously, if you've got beneficiaries who might have particular needs or you might have concerns about, they can be addressed in a will far better than simply hoping that things would work out without one.
Yes, I'm sure time-wise and stress for people already grieving, them trying to figure it out and hoping it works out is not great. Is it a situation where people are traditionally, if they have things of value, maybe considering passing these things on before they die? Is that something that happens, or?
That's certainly an option, and people do that for a variety of reasons. Perhaps as they retire from work and looking to rearrange their affairs, or they got for other reasons. there's a natural desire to do that, or it could just be passing on personal items or things like that during someone's lifetime. But there can be tax reasons why you can or can't do that. So sometimes the will is still the best option for dealing with those sorts of issues.
And what do you need in a will? What do you need to set up a will? I'm sure people are using ChatGPT for this, which is not a legally binding tool. What do you actually need in a will?
Really, the formalities, and then they date back to the early 19th century in England, to the Wills Act of 1837. So it's been around a fair amount of time. The English succession law is very wide open. You can benefit pretty much who you want. The formalities for a will are really to do with the execution of the will, having witnesses present and ensuring that those formalities are done. So there are some, but in terms of what you can do in the will compared to perhaps other jurisdictions, there's an awful lot of flexibility there.
Mm-hmm. Okay. And then do you have to, I know respectfully, do you have to have a solicitor to help you do your will or to make it legal?
No, you don't. There are, as you suggested, versions of wills available on the internet. You can buy them in shops, will kits and things like that. They are around, and provided you follow the instructions as to particularly execution, then yes, they would be a valid will. So you don't need a solicitor as such. But where the solicitor's role comes in, obviously, is identifying problems you may not have thought about, whether that's in how to benefit family members or deal with particular situations, deal with business assets, for example, if you still hold business assets at your death, beneficiaries who have particular needs or concerns about, and generally ensuring that the will is drafted to maximize any available tax benefits, and sometimes also to avoid any problems in the drafting. It often happens when someone drafts their own will, they forget to include some provisions that means that there's a gap in what they say, and it's not clear then who benefits or why or how the wording works. So often having a solicitor just irons out those problems.
And I have to say, like, for someone that lives in central London and thus does not have much savings or property to worry about, I think of things like end of life care and decisions that have to be made. And I know for queer couples, it may not always be very clear for stuff like that, or rights to hospitals. So having those things written down is very good as well.
They are. They wouldn't normally feature in a will as such.
It's separate. It's not part of the will. Okay.
Not part of the will, but there are other documents and other things you can do, and often it's sensible to put those in place alongside the will. So that would be another reason to take professional advice, because all of that can be done at the same time to ensure you've got a package that, as you said, can benefit blended families, queer couples, or different people with different needs, legal needs that need some specialist advice.
Okay. And what is a probate then? And how is that different?
Probate is what happens when someone has died. A grant of probate is essentially a declaration or an order issued by the court that confirms that the person named on it is authorized to deal with the deceased affairs and receive money or distribute money. Now that comes in really to deal with things like selling a house or dealing with investments. So what happens, as I said, is when someone dies, the executor is named in the will, and they have that authority coming from being named in the will. But to prove their authority, for example, if you're trying to sell your deceased relative's house, you need the grant of probate to actually do that. So it's another step in recognizing the authority and enabling things to be done. In order to get the grant of probate, you also need to deal with the deceased tax position in the UK. The UK has inheritance tax, or what may be called a death duty. Not every jurisdiction has that. So it's important to bear that in mind. If someone's listening from outside the UK and has assets in the UK, inheritance tax is something to bear in mind, because that will need to be looked at as part of the administration process. And that's normally called probate or estate administration is in the general terms, but the grant of probate is a legal document that's required to deal with assets.
And for sure, while we have two clearly people in the same market, the same company, it's part of our global community. So there are a lot of cross-border things. That's kind of one of the benefits of the community or network, is that you can work with other trusted financial advisors, lawyers, etc., in these cross-border situations.
Absolutely.
But yeah, so we have a will states things, or you don't have a will and things are not as clear. But even when it's clear, I guess disputes happen, right, Adam? Tell me more.
Yes, that's right, Jennifer. They do happen, and they happen quite a lot. I mean, there are various grounds on which you can challenge a will, and people do challenge them. For example, and one ground that's quite common is people perhaps argue that the deceased at the time didn't have the capacity. So there is a legal test when it comes to testamentary capacity, but particularly with things like dementia on the rise, people may try to argue that at the relevant time the deceased didn't have capacity, so the will isn't valid for that particular reason. There are other grounds on which people do challenge wills. They may argue, for example, that perhaps the deceased was unduly influenced into making the will. Perhaps there was some form of duress, and this doesn't truly reflect what their intentions were. Fraud, perhaps, is another one. Sometimes people allege that this is a fraudulent document. So there are a number of ways people can challenge the will itself, and then sometimes you get almost, I guess, a kind of a collateral attack on the will in a way, where perhaps a will doesn't make provision for an individual. So there is an act in England and Wales. It's called the Inheritance Provision for Family and Dependents Act. It's a 1975 act. What that essentially does is it allows certain categories of people, so spouses, those children, to bring a claim where perhaps a will doesn't make provision for them, or even the intestacy rules, where provision isn't made for a certain type of person, to go to the court and to ask for provision to be made for them out of the deceased's estate. There are certain categories of applicants that say that they can make it. For spouses, it's a slightly higher test. And what the court will look at is it seeks not to penalise spouses, so it will perhaps look at what a spouse would have been entitled to had the relationship ended in divorce rather than death. For other types of applicants, it's a slightly lower threshold. It's what is reasonable for their maintenance. So if you are perhaps financially dependent on someone and their will doesn't make provision for you at all, the court will look at potentially awarding you something that's slightly more than what's needed for your subsistence, but it won't necessarily grant you what you need to live a life of luxury.
Okay, yeah. Which, again, I live in London, so the luxury is in the life, not in the living here. No, and how often does it reach the point of litigation? I guess there's steps before that are brought up, or?
Yeah, so normally in England and Wales, and this applies not just to probate disputes, inheritance disputes, but across the board, there's always an expectation by the courts that parties engage in what's known as pre-action correspondence. So there are the civil procedure rules in England and Wales for commercial litigation, other types of litigation. There is a particular code for probate matters, but the courts will expect parties in the first instance to put their case, set their case out essentially in what's known as a letter of claim to send it to the other side. And then parties are expected to try to resolve those matters initially without recourse to the courts. Courts are generally seen as the place of last resort. And for us particularly, and perhaps more so with inheritance disputes than other types of litigation, there are other means to try to resolve things. They're called alternative dispute resolution, and they include such things as perhaps mediation, which you may have heard of. And I think personally, I think for contentious probate inheritance disputes, perhaps there maybe is more of a push towards that, because obviously once proceedings are issued, it becomes very acrimonious. Litigation isn't cheap. It can potentially entrench and deepen divisions between families. And as we all see, I rarely does a week go by nowadays when I don't see in one newspaper an inheritance dispute splashed across the pages. And whether families want all of this to come out in the media and for the country to know their disputes, I suspect not. So yes, in the first instance, yeah, parties are expected to kind of set it out before they go to the court and to try to resolve it without recourse to proceedings.
That makes sense, because these are often really sensitive times, and it is, I assume, most often family and the loved ones of the people that are deceased, who I don't think are typically haunting them and trying to cause pain. It's a consequence, not an active harm.
Yes.
I'm timing out. Is there anything else, any other topics you wanted me to talk about before I wind it up?
I think we could just make the point, obviously, that for people based in multiple jurisdictions, assets in different countries, they need to think about potentially having wills in those different jurisdictions. Not all succession law, not all procedure on death or tax systems work in the same way. Certainly, there's great differences between common law jurisdictions like England and Wales and civil law jurisdictions like basically continental Europe. They have very different systems and the way things work. And there can also be just practical advantages in having wills in different jurisdictions to help speed up the process. So you can do things in parallel in each jurisdiction without having to start in one jurisdiction, wait for that to be finished, and then start somewhere else.
Wouldn't they then be at risk of conflicting because the laws are different in these different places? And
that when it comes back to, again, taking proper advice at the time the will's drawn up, you can certainly, for example, restrict a will drawn up in England and Wales to just apply to England and Wales. So if you have assets in America, for example, or France or Australia or wherever it happens to be, you can have separate wills that effectively sit alongside each other to enable you to deal with the different systems and trying to impose, for example, what works well in England on a different jurisdiction can lead to problems in terms of different tax treatments or interpretation of the will or validity or things like that.
what are some other topics that people should be considering when they're talking to lawyers or solicitors about this planning?
Say that what is always helpful is to have the person making the will to think about how things would be dealt with after their death. So it can take an awful lot of time sometimes in gathering details of assets together and things like that. So whilst obviously you've got to be mindful of things like security of data and things like that during your lifetime, there are steps you can take in terms of helping people by giving hints and clues to where assets are and things like that. You can provide that information. You can keep that information yourself so that it can be accessible after your death, and tremendous help to people. And as well as taking advice at appropriate times as life events come along. Normally, it's things like births and deaths and marriages, retirement. They're all useful triggers to think about your affairs so that you can do with things to make things smoother for your relatives and your close family after you've died.
And then, Adam, on the other end of this less prepared spectrum, we've talked about some disputes. Are there other areas that people should be considering that are?
Yeah, I could probably talk to you all afternoon, Jennifer, about what we do. I mean, yeah, so there are challenges to wills as we've discussed. There are claims under the Inheritance Act, but there are a number of different ways in which disputes kind of arise. Burial disputes, for example, is an area that we can deal with. So you do sometimes, perhaps you can imagine a situation where perhaps somebody's had a family, they divorced, set up a family with somebody else, and they're perhaps two rivaling factions of children, and there are then disputes that arise over how the deceased's body should be disposed of, perhaps where they should be buried. The courts do have a power to deal with those types of cases, and they tend to arise not frequently in the courts, but they do arise where you have arguments over those sorts of things. And there are a number of other cases. Estoppel, proprietary estoppel is quite a large area for disputes, and it's something you do see quite a lot particularly in the media. Cases where, for example, perhaps children, it rises quite often in farming context, where perhaps children have been promised, you work on the land, this farm will be yours one day, and perhaps the parents kind of resile from that promise. There are certain kind of criteria. There has to be a clear representation. Somebody has to rely on it. And relying to their detriment. But in those circumstances, when someone then passes away and perhaps the expectation that they had doesn't come to fruition, that is another way in which disputes arise in inheritance context, and that's quite common in my experience.
And again, these are all situations where it's better to have them in writing before, but otherwise you can help out in these.
I think with all these things, yeah, and I'm sure Patrick will agree. Yeah, I think very much, yeah, you can do a lot to kind of mitigate these risks. I don't think you can eradicate it entirely. I think disputes will always arise, but there is a lot that you can do to help minimise and to reduce the risk of disputes happening.
Absolutely. Thank you both so much. If people inevitably have questions, because, well, we've all have people that die, hopefully, because that means we have loved ones that we're missed. So how do they get in touch with y'all?
So they can get in touch with us. I don't know just for whether any way we can perhaps mention or send a link to our website. I mean, we are at Colman Coyle, which is based in Islington, Wells House. So if you Google us, I think we are the only Colman Coyle that I know of. But we're very easily, yeah, it's easy to Google, and then we have a contact page on our website where people can put in inquiries, and I think both myself and Patrick are on the website with our email addresses if people want to get in contact.
Okay, great, because these are conversations everyone should be having. Thank you both so much, and thank you, listeners. And if you know people that you think would benefit from this conversation, please do share it. Thank you so much.
Thank you very much.